Good morning, everyone. Everyone, can you hear me okay? All right, great. Thank you very much for coming in this morning. I know it's a little early. So I'm going to get started right away because I'm told we're on a very tight time frame here. My name is David Linscomb. I'm an attorney for the Federal Trade Commission. I work for the Division of Privacy and Identity Protection. I've worked there about 13 years now. And today I'm going to be talking about some privacy and data security law, some things that have been happening this year and the last couple of years, and things that might be of interest to you, may impact your business. Let's see that again. All right. First, a disclaimer. I work for the Commission, but I do not speak for the Commission. What I say is my viewpoints and not necessarily that of the FTC. So in other words, if I say something real stupid, that's on me, not on the Commission. They're very particular about that. All right, so let me tell you a little bit about the FTC, the Federal Trade Commission. We're an independent law enforcement agency, and we have two main missions. One is a consumer protection mission to protect consumers in the marketplace from deceptive and unfair business practices, and the other is a competition mission where we try to stop anti-competitive practices in the marketplace and make sure that we have a free market that is working as it should be. It's a sort of trust buster side. I do nothing with that, and so I'm afraid if you have any questions about that, I'll just look dumb at you because it's a whole different part of the agency. As far as the data security and privacy, we basically have been enforcing some version of that for the last 15 years or so. And we do that through enforcement, in other words, bringing lawsuits against companies who have violated the law in one way or another, policy initiatives where we've tried to encourage certain self-regulatory or legislation to help improve data security and privacy, and a lot of consumer education and business outreach where we try to help people understand what they need to be doing to protect the information they have in their possession and for consumers to protect themselves and deal with identity theft. So now we'll turn to privacy in the United States. Unlike other countries, there's no single law that governs privacy and data security in the United States. We don't have something that just tells all businesses that they have to have a certain level of data security or that certain conduct is not allowed with people's personal information. That just doesn't exist in the United States. What we have instead is what some people would call a patchwork of different laws and regulations that govern either specific entities or specific practices. And I'll get into more detail on that in a second. There's also state laws that can impact you depending on where you're operating your business and also where you kind of reach out to. And also private causes of action. You can get sued for certain things under data security and privacy. Those have had varying degrees of success in the United States. That's kind of outside of my topic today, but it's obviously something that is concerning to businesses and a reason they want to take good care of the information they have in their possession. And in addition, and this is very true in the last year or two, some international laws may come out and affect businesses in the United States, and we'll talk about that a little bit later on. All right, so let's talk about the federal privacy laws. These are the main ones. There may be a couple that apply in very specific situations. The first is the Fair Credit Reporting Act. Probably a lot of you have had to deal with this in one way or another in your businesses. It involves credit reports and what can be done with them and how you have to dispose of them. There's the Gramm-Leach-Bliley Act, which is sort of my specialty, and that deals with financial institutions. So as I was saying, this is one of those regulations that apply only to certain entities, and in this case, financial institutions. And it has two main rules under it, the privacy rule and the safeguards rule. The privacy rule may also be known as Reg P, depending on whether you're under our jurisdiction or the CFPB, the Consumer Financial Protection Bureau's jurisdiction. And then the safeguards rule. And then next two things probably don't have a whole lot of application to automobile dealerships, hopefully. One is Hipaa, the Health Insurance Portability and Accountability Act. And that really is governing healthcare providers and their patient information. If you've ever been to the doctor, I'm sure you've filled out some forms giving them permissions for things, and it is a very important but not real applicable here. And then another one that I hope doesn't have too much applicability to car dealerships is the Children's Online Privacy Protection Act, which involves collecting information from kids 16 or under 16. So hopefully not selling cars to 13-year-olds too much. And then finally, there's the Ftc Act. That's probably the closest thing we have to an overall privacy rule. It's not a privacy rule. It basically just prohibits unfair and deceptive conduct in the marketplace, and that can sometimes have applicability to data security and privacy. I'll discuss that a little bit more. As I said, FTC's been doing this for about 15 years, and we've developed some principles, some kind of guiding principles over that time. I'd say the number one is that security has to be reasonable and appropriate in light of the circumstances. So we don't say to businesses, you need to have perfect security, because there's no such thing as perfect security. What we say is you have to look at the size of your business, the amount of information you have, the sensitivity of the information you have, and how vulnerable it is, and you have to take appropriate steps to guard it. Steps that make sense from a risk-benefit position. We don't ask that it be perfect. And accordingly, just because you have a breach doesn't necessarily mean that you've had bad security or the unreasonable security. Because, as we've seen in recent years, there are big entities out there with extremely good hackers that can get into just about anything should they turn their focus on you. But we do ask that it be reasonable so that you can at least stop the people who you can stop. It's sort of making sure your doors are locked. Yes, someone could still maybe get in, but you need to at least lock your doors. And then on the flip side of that, just because you have had a breach doesn't mean that you have reasonable security. It just may mean that you're lucky. And so that's something we always tell people, you need to pay attention before the breach. We have brought a couple of cases over the years where a company's poor data security has come to our attention before the breach, and we do have brought suit and asked that and require that they get that security in order. Although we do usually find out after the breach, unfortunately. And finally, data security is an ongoing practice. And this is something that's very important to businesses to understand. You can't just set it up when you first start your business and then forget about it. Data security is a constantly changing landscape. The threats change, the technology changes, and you need to be aware of it as much as you can and adapting to it. So let's go through some of the individual statutes. I'll just focus on the ones that probably have a little more applicability to you. I'm not going to go into too much information because I do want to focus on more current occurrences. First, the Fair Credit Reporting Act. As I mentioned, that involves consumer reports that you get from consumer reporting agencies, your Equifax, your Experian, your TransUnion, as well as smaller ones, and resellers. And basically what it says is the consumer reporting agency cannot give a consumer report to anyone unless they have a permissible purpose for getting that information. So that's generally a credit transaction, extending a loan, selling a product on credit, insurance, employment. If you get consent from the employee or the potential employee, you can get a credit report during the hiring process. And anything else that they give you the consumer gives written consent for. And then it also requires that the CRAs, the consumer reporting agencies, actually have some system to make sure that when you buy a consumer report that you actually have a permissible purpose. We've had to take action on that in the past where resellers were just giving it to anyone, including hackers and identity thieves. So don't do that. I mean, you're not consumer reporting agencies probably. All right, Gramm-Leach-Bliley. As I said, that applies to financial institutions. And financial institutions here has a much broader definition than most people generally think. It's not just banks or credit unions or payday lenders. It's basically any company that engages in a certain list of financial activities. As a result, automobile dealerships are generally considered financial institutions because of their role in obtaining financing for the cars. And obviously, if you're a buy here, pay here, where you're extending the loans yourself, it's more clearly a financial institution there. But it's very rare that there will be a dealership that is not a financial institution. So the rule that applies to everyone who's covered, there are two rules, the privacy rule and the safeguards rule. And as I mentioned, there are two versions of the privacy rule, one run by the FTC, one by the CFPB. For automobile dealerships, the only real difference is if you're a buy here, pay here, you're covered by the CFPB. Everyone else is covered by the FTC, but it doesn't really matter because they're identical rules. You just have a different thing on the bottom of your form saying who it's complying with. So, real quick, the privacy rule is something that you may be familiar with. As you start a new customer relationship, you're required to give your customers notification of certain of your data security practices. It generally requires that you notify consumers before you share any information with non-affiliated third parties. An affiliate is someone you have some sort of corporate relationship to. Generally, you can share there without giving a chance to opt out. And you have to do this before the customer relationship begins. You can't extend the loan and then tell them this. You have to tell them first. We have a model form that is very widely used that you can include in a packet. It's very easy to fill out, and it's been in circulation for over 15 years now, I think. It's been very useful. And in some cases, if you have an ongoing customer relationship, you may need to send an annual notice to the customers, although there's been some changes to the statute that make that less common now. Unless you are changing your practices a lot, you generally will not need to send those annual notices. All right, so the safeguards rules, where I'll be spending a little bit more time because things are afoot there and may have more impact on the business side of things. So the Safeguards Act was first enacted, Safeguards Rule, that should not say Act, was enacted in 2002 and went into effect in 2003. Since then, we've made no changes to the rule, which is pretty impressive / notable because, as you know, 16 years in internet time is about 300 years. So this is an ancient rule. And so, as all things must change, after seeking comments, we issued a notice of proposed rulemaking on March 5th of this year, suggesting some changes to the safeguards rule. And I'll get into that. But first, I want to tell you what the current rule says. The current safeguards rule requires that all financial institutions have a comprehensive information security program. And it kind of echoes what I was saying before. It has to be appropriate to your size and the complexity of your business, the kind of information you have and how you use it. Obviously, if you just have a list of names and emails of your customers, that is less sensitive than if you have a complete credit history and social security numbers. And you need to design your security program to reflect that. The security program has to have employees or employees in charge of it to coordinate. It has to identify reasonably foreseeable risks. Those are both internal and external risks. So internal risks are mostly we're talking about employees, but other kinds of authorized users who might, through either carelessness or maliciousness, go in and misuse the records or compromise them in some way. And external risks, which we're basically talking about hackers there. And you have to, and those are risks that affect the security, so whether someone can get at the information, the confidentiality, keeping it secret, and the integrity, making sure that it's not being altered. And then you have to assess, make sure that the safeguards you have in place match those risks. And finally, the security program has to address training of your employees. You have to address the actual information systems that you have, so the actual computers and systems you have set up, and how you're going to detect, prevent, and respond to attacks. And then generally the financial institution has to design the actual safeguards, so the actual security, and then test it occasionally and make sure that they're doing their job. You have to then also, a lot of companies use service providers that are going to be getting the information to do mailings, to do processing. There's any number of things. You have to make sure that you select one that can actually do the safeguards you need them to do for the information they're going to have. And then you have to have a contractual requirement with them that they will do so. And then finally, you have to regularly evaluate the information security plan and make sure it's still working and then modify it based on that testing, or if you change your system, if you get a new service provider, or change the makeup of your computer system. And then finally, anything else that you might know that you have. So that is pretty much all the current safeguards rule says. The plus of that is it's flexible, it's process-based. You can do whatever you want to meet those requirements. And it lets you develop programs that are appropriate to you. And it doesn't need to be updated. As I said, it's been here for 16 years, and it's still clocking along, working pretty well. Some potential downsides to the current approach, though, is it doesn't really give financial institutions much guidance on what it should actually look like, the information security program. What do you need to do? And we often have businesses come to us and say, well, it's nice that you said that it needs to be reasonable, but what does that mean? And so this is an attempt to do that, our proposed change. And like I said, that was just a couple months ago. We issued the proposed rule. And it is trying to keep that flexibility, but give a lot more guidance as to what that entails. And you know, I'm not trying to sugarcoat the fact, yes, it does have additional requirements as a result. But we suspect that most businesses are already doing most of the things. That this is really an attempt to just clarify, oh, I'm doing that, I'm good. And for those companies that are lagging behind, make it clear to them that they are lagging behind and that they need to take care of this. So we're hoping it provides clear requirements, but still gives you that flexibility. And as a note, if any of you from New York, you may, or pay attention to these sorts of things, you may notice that it's very similar to New York cybersecurity regulations that came out in early 2017. And that's because we thought they did a really good job and decided to base our proposal on that with some changes appropriate for our rule. So it's still based on a comprehensive information security program like the existing rule. It's still based, to the size and complexity of your business and the sensitivity of the information. As I said, includes more detailed requirements. But all those requirements individually are still process-based. We don't say you need to have this kind of access control, you need to have this kind of network management. We just say you need to address these areas. And also, because we know that companies have different, some of these might be difficult for smaller companies, we've exempted companies that maintain a sufficiently small amount of customer information. It's not based on the size of the company, because there are very small companies that hold a whole bunch of information, particularly on the internet side of things. They may have only a handful of employees but have millions of consumers' information. They do need to meet all the requirements because we need to protect that information. But if you have a business that doesn't entail a large number of customer information, you may be exempted for some of the written side of things on this, so that it's a little less burdensome. So let me just go through what the new rule would do if it is adopted. One minor change is that instead of saying it can be, you can have more than one person in charge of the program, we say no, you do need to have one person in charge, someone who's going to be answering for this. We call them a CISO, a Chief Information Security Officer in this. There's no requirement that you call them that, or that was just for ease of discussing it in the rule. But and we also say they have to be qualified. That is something that was not expressly said before. So no more putting your administrative assistant in charge of your data security program unless he or she happens to be a data security expert. Then the risk assessment part, before it didn't need to be written, we're saying no, it needs to be written because there were too many businesses that were not really doing a thorough risk assessment. They would just sort of eyeball their system and say, oh yeah, we know our risks. This is requiring that you actually write down and go through it and do a formal process of risk assessments. And then you'll need to just update it periodically when you think there's been changes, because it's, again, not something you can just do once and forget. And you'll have to regularly test and monitor the system to make sure it's working, your program. And you can either do that through a continuous monitoring, which I think a lot of businesses have, something that just sort of is always keeping track of who's going in and out and making sure all the systems are in order. But if you don't have such a system, then you'll need to do either you'll have to do annual penetration testing and biannual vulnerability assessments. Those are things you can get through third parties or do yourself. We go into a little more detail on training as well, although again, probably most companies are already doing this. You have to provide security awareness training to basically any personnel that might have access to information, and that really in most companies is going to be just about all your employees, including janitorial staff, because they'll be disposing of documents and going through people's offices. And this is just kind of more generally what most people are familiar with, where you'll have some general safety protocols and what your rules are, and letting everyone know what the company's rules are. And then there's the next step, your information security personnel. First, you have to make sure that they're qualified. And we don't go into details about qualified. It's up to you to decide. You know your business, but you need someone who's appropriate. And I want to be clear that it doesn't have to be your own employees. You can use a third-party service provider. I think that's becoming more common, where companies will just hire a company that will take care of the internet side of things and their data security. And then you'll have to train those security personnel and make sure that they kind of stay up to date on things, because it's very important that your personnel, including the third party, is actually aware of if there's been a security issue that has been put out and that you need to patch things. You need to keep up with it, or you're going to have big exposed weaknesses in your system. So as I said, most everything in here is just kind of generally talks about these areas and leaves it up to you. There's two that are a little more specific, and that's encryption and multi-factor authentication. But in both of those cases, if it's not appropriate for your business for one way or another, either because of expense or just how your business works, we allow the CISO to come up with a different approach, and they just have to document that, okay, we don't have multi-factor authentication, but here's why, and here's what we're doing instead. Let's talk about encryption first. This would require that all your customer information be encrypted when it's being transmitted over external networks or when it's at rest within your system. So again, this only applies to customer information, not everything else in your system. The transmission, it's only when it's going outside your system. So if you're sending it around within your system, it doesn't need to be encrypted. But the minute it leaves, the customer information needs to be encrypted. And then again, if encryption is infeasible, you can come up with other ways that you're going to protect this information. Just have to have the CISO sign off on that. Multi-factor authentication is something that you may have had some exposure to, probably more, at least as a customer, if nothing else, with banks. And this would require that a financial institution have multi-factor authentication for anyone who's accessing customer information. So the three factors for multi-factor authentication are knowledge, possession, and inherence. And you have to have at least two of those. So knowledge is things you know. So this is a password or biographical information. If you do something that asks for your pet's first name, something like, or your first pet's name. Your possession factor, that may be a little token you have. That's more common with employees. Or verifying that you have a device, a particular device that you know belongs to the authorized user. That's very common today, where you'll get a passcode sent to you to verify that you are the person you say you are. And inherence factor is not as common, but it is growing more common. That's the things you are. So that may be your fingerprints or voice. Probably a lot of us have a little fingerprint detector on the back of your phone. That can be used as a factor as well. And again, if this doesn't work for your business for some reason, then you can come up with an alternative way of protecting the information. But you do need to do something to make sure that the people who are accessing the information are the people who should be accessing the information. The next steps for the proposed rule is that we've asked for public comment, and that period ends August 2nd. You can submit comments in writing or go to regulations.gov. We encourage everyone to give comments, negative, positive, or neutral, or how great I am. Any of those are welcome. But the more input we have, the better the process can go. And then finally, I just real quick want to talk about the Ftc Act, because that is something that you have to be aware of as well as a business owner. That is, again, the general law that we have. It's not a privacy law that prevents deception and unfairness. So for deception, it's what it says on the tin. If you have told someone if you've told customers something about your data security or your privacy practices, and that is not true, then that would violate this law. And then finally, there's unfairness. And unfairness, what that means is if you are having a business practice that's causing harm to consumers, and that harm isn't outweighed by benefits, and the consumers can't avoid it, which pretty much sums up a lot of data security problems, because customers don't know what your data security is, so they can't avoid your business. And so that may result in an unfairness violation if, for example, you have really poor data security that is exposing your customers to risk. And we have brought most of our data security cases under one form or another of the Ftc Act. Because, as I said, we don't have any other law that applies to non-financial institutions or other than the specific use ones like Ccpa and FCRA. All right, so that's the federal side of things. Now let's talk a little bit about some things that are happening at the state level. I am not an expert in any of these state laws, so I'm just kind of giving you a heads up on them and a brief overview. But I just want to make sure you're clear I am not enforcing any of these, so I don't know them as well. But I do want you to know some of the things that are up because I think it's showing a real interesting pattern in the last couple of years. First, as I mentioned earlier, is the New York Cybersecurity regulation. It's more or less what I laid out for you for the proposed rule, with a couple additional requirements, ones that are, if you're affected, pretty important. One is it requires that all of your breaches, any kind of data security event that you have, has to be reported to the government. And you have to make regular reports about your data security to the government. We do not have that in our proposed rule. And it applies to any financial institution that's registered in New York. So it is obviously going to have a pretty big national effect for companies that are registered, because there are a lot of companies that are registered in New York. This is one that you may have heard quite a bit about. It is causing panic and dismay as well as hope and everything else. It is the California Consumer Protection Act, the Ccpa. It is been passed, has not gone into effect yet, and it basically is designed to give consumers more transparency into what is happening with their information and some choice about how companies are using their information. Their personal information. And it's supposed to come into effect on January 1st, 2020, although I understand that's a bit of a moving target for various reasons, because it has been pretty chaotic. Briefly, there was this was a proposition that was passed by the people directly. There was a very strict version of this that was passed. The legislature and businesses kind of freaked out and decided to come up with their own that hit most of the parts, but was maybe a little more workable for businesses. And that's what's come into effect. But it happened so quickly that there are some issues with the rule. And so that is an ongoing process of amendments and figuring out exactly what's going to happen. But what it basically does is it requires companies to disclose to consumers what personal information it collects, what purpose they are collecting it for, and whether they're sharing it. Which, is not too unusual. I think most companies do some form of that in their privacy policies. It's the next part that's probably causing a little bit more panic in people. It gives rights to consumers to opt out of the sale of their information. So if you have some aspect of your business that involves selling personal information, for the most part, California consumers can opt out of that. They can also request deletion of any information you have by them. That, I think, is probably causing the most panic because a lot of companies, like the bigger internet companies, have no idea how they will do that. But I'm confident they will figure out something. They can't ask you to delete something that's essential to the functioning of the service. So, for instance, if they have a car loan, they cannot ask you to please get rid of all the information concerning the car loan. I'd rather you not have any information about me. Well, as long as that car loan is out, you can keep the information. But a couple years later, if they come to you and say, I'd like you to get rid of all the old information about me, for a California citizen, you'll need to do that. And they define personal information pretty broadly. This is any information that's capable of being associated with a consumer or household. So that it's not just name, social security number. There are lots of things. Given the capabilities of companies now of connecting information to people, purchase histories, geolocation information, that may not have your name on it, but if it's capable of being associated with you, it's going to be covered by this. Now, ultimately, the California Attorney General is going to be enforcing this. They're not private rights of action. You won't be sued by customers generally, with the exception of data breaches. There is a private right of action there. If a consumer is injured by a data breach of information that you held, they will be able to sue you. The Attorney General will be issuing rules under the law, and as I said, that is very much an ongoing process, as well as the amendment. And I do not know what the current state of that is, because it is constantly moving. But it should get real exciting in California beginning of next year. Here's a smaller one, but one I thought was interesting. This was proposed near the beginning of this year in Hawaii. That would outright prohibit the sale of geolocation data without consent of consumers. So this covers any data collected either by phones, cars, or any device that uses satellite location technology. So if I know some automobile dealers have geolocation put in their car so they can find a car that if the person defaults on it, no problem with collecting it, prohibition on selling it, that information. That is still just proposed. It hasn't been passed as of this morning when I checked. But as I said, I think these rules, and there are others, there are other statutes that are being either proposed or passed, are showing a desire from the states to get more involved in both the privacy side of things, what people can do with your information, and the data security side of things. So I think we're going to be seeing more and more of this in the coming years because, as I said, in the 13 years I've been doing this, I've never seen a level of interest and concern like I have recently. And I think there are probably a few reasons for that. There's some real concerns about the large internet companies, Google and Facebook, and the information that they have, and some of the sociological effects they have, and things like that. But also we've had some major data breaches. The Equifax breach was monumental. I've often said that we really wouldn't see any real movement on this legislation until we had an Exxon Valdez of privacy. For those of you who are old enough to know what the Exxon Valdez is, it was a major oil spill. And the Equifax may have been that breach. It may have been the one that was just big enough that affected enough people that people started to stand up and say, we need to do something about this. Our current approach isn't doing enough. So that's generally what's going on in the states. And I'm going to cover one that on its surface probably won't affect you very much, but you might be surprised. And that is the General Data Protection Regulation. It's known as the GDPR. It went into effect in May of 2018, and it is an European Union law. So generally not going to affect you. However, it applies to any business with information about an EU citizen, regardless of the location of the business. So if you have a car dealership in Texas and you sell a car to a German citizen, you will be covered by this rule, at least as concerned the information you have about that German citizen. It defines personal information not quite as broadly, I don't think, as California, but still pretty broadly, as any information related to a person that can be used to directly or indirectly identify that person. So you have to actually be able to identify the person for it to be covered, but as opposed to just being associated with someone. And then every time you want to use data for a new purpose, you're going to need to get permission from that EU citizen. There are a few other ways that you can do it, but my understanding is that generally it's going to be a consent issue, especially here in America where we wouldn't have the expertise to do the things that the EU would require. And it has a very strict data breach notification. That's 72 hours. So if that German citizen that you sold a car to, his information is breached, you're going to need to let him know within 72 hours. It also gives that EU citizen some individual rights. It's very similar to what we saw in California. It is right to access, so they can say, look, tell me what information of mine that you have, where it is, and what you're doing with it. And they can ask for a copy of all the data you have about them free of charge. They also have a right to be forgotten, and that's very similar to what they have in California. they can say to you, please erase all personal data I have, and you will need to do that, again, with some limitations. Yes, please.
Why would that Texas deal be unblocked?
Because the EU has said that the rule applies to any company in any location. Well, you may not, but if you have any way that they could get at your assets, if you have companies, any company, yeah, I mean, here's where we get outside my expertise. So I want to be very clear on this. But there are situations in which an EU citizen can come to you in Texas and sue you there under EU law because it applies. I am going to stay real clear of that as to what exactly that would mean. That's legal advice. I will say this is just something to be aware of. And if you are concerned, talk to your lawyers about exactly what it means for your business. Because as far as the EU is concerned, it covers you. So keep that in mind. More concerning is maybe not coming to Texas to sue you, is more coming to somewhere in EU suing you, getting a default judgment, and then the minute anything you own comes across EU's grounds, they can get it for you. So something to be aware of. So that is about it, which I probably talked too fast, so we've gone a little bit. Hopefully, we have some questions. But I wanted to just let you know about some of the materials that the FTC has. We have done a lot of great education pieces, and I can say that because I had nothing to do with them. That was other people. And you can find most of them at business.ftc.gov. Those are the ones aimed at business, obviously. In particular, I'd suggest we have something called Start with Security, which was a document we made that basically went through all the lessons and we've learned through enforcing the law over the last couple of decades, and what that means for businesses and data security. And then there was Stick with Security, which was a follow-up set of blog posts that kind of went into more depth. And because it's my rule, GLB compliance guides, also FCRA compliance guides, that have some real good advice on, particularly for small businesses, on how they can comply with those rules and statutes. So that's about it, but I would be more than happy to answer questions to the extent I'm able. Yes? Absolutely. Sure, absolutely. So initially, the rule was pretty simple. It said if you have an ongoing relationship with a customer, so you still have an outstanding loan or you are providing some sort of other financial service to them, then once a year you're going to need to send them a notice that basically is the same notice you gave them initially, saying, just so you know, this is what we're doing, and again, you can opt out. Well, that rule was changed by statute it was called the FAST Act a couple years ago, and that basically says that as long as you're not sharing information in a way that requires an opt-out, so as long as you're not sharing with non-affiliated third parties, there are some other exceptions. If you're doing something with service providers, that's fine. If you're sharing information that is necessary for a service that the customer has requested, so if they say, please change my address, and you have a processor that does that, that's fine. Or you're asking for you just send some information, you can do that. That doesn't affect this. And then there's a few things like subpoenas and audits and things like that don't trigger it. So as long as you're not doing any sharing with third parties, and it hasn't changed since the last time they got a notice, you don't need to send them an annual notice. What would trigger it is if you change it in some way that's material to them, and it requires an opt-out. And so if you do that, you'll need to send a new notice, and then you may have to then continue to do notices if it requires an opt-out, if you're doing sharing outside the third party. And it really depends on the business. I'd say generally most companies just avoid it by not doing that kind of sharing, but there are obviously companies that do, and in which case they do need to continue sending the annual notices. Generally not. And again, let me be real clear. I can't give you legal advice on this. You need to talk to a lawyer. But just speaking generally, most notices you give will say we share with affiliates or something to that effect. So if that hasn't changed, you're still sharing with affiliates, and it doesn't require an opt-out, which sharing with affiliates doesn't, it's probably not going to trigger a new requirement that you send it out. So what has, for most businesses, I think it has really just become the initial notice. But it is something you absolutely have to be aware of down the road. If you consider changing, then that new requirement will kick in. Yes? Yeah, and again, not only can I not give legal advice, I certainly can't give technological advice because I'm not a technologist. But yes, I mean, that is something you have. The example we use in the proposed rule is those things where probably most of you come across it when you're trying to change your password or access your information. Well, they'll send you a text with a new password. You type it in, and that shows that you have possession of that phone. I will note that texts are not the best way to do that. The NIST, which is an organization that handles some security standards, has cautioned against using text because they're fairly easy to spoof. But that idea, like you said, an individual program that sends out a password or just says, "Hey, I'm here. This is this book. Or this is this computer. Here's a passcode that lets you know." Right. Yeah. If it tells you that it tells the system that they have a particular computer that you know belongs to a person who has a right to access this information, it will absolutely satisfy that. I suspect that's how a lot of people will handle their own employees accessing. My particular computer has a little dingus on the side that I can put a security card in. That serves as that. And then as well as a password. So there's my two factors. And then when I log in from home, there's some additional stuff I have to go through. Right. So that is the main. I think at the office place is pretty straightforward how it will be done. Companies have to be very careful of people accessing remotely. That is often a weakness in companies' data security programs is their remote employees, and so you need to give some real thought to that. Uh-huh.
How long do you usually take for something to get required?
Well, one of the joys of government is you never know. And I would suggest with this one, it is very complex. There's some controversy around it. I suspect it will take a bit of time. I really can't even estimate how long. Anything I say will prove to be horribly wrong.
It's not a matter of months, it's years.
Probably not. I would be shocked if it happened in a matter of months. But if someone in the commission says we're doing this, we're doing it now, I'll do my best to do it then and do it now. But there will be lots of talk and discussion, and I don't think anyone will wake up one morning and find that they're under the new rule. It will happen relatively slowly, and we will, to some extent at least, have a enforcement delay where it will be passed, and then there will be some amount of time you have to get your house in order before it actually impacts you. Anything else? All right. Well, you get out early. Enjoy it. Do good things with your time. Thank you very much. And if you have any questions that you didn't feel comfortable talking out loud, feel free to come here. I'm here for another 15 or 20 minutes.